Okay, good afternoon, everybody. Thank you very much for joining us this afternoon. My name's Simon Murnane. I am the Clinical Operations Manager here at Ainscoe Associates, and I'm delighted to be hosting this afternoon's webinar. We're very excited by this afternoon. We've got three excellent and well-known guests on our panel. We've got Andrew Williamson, who is a defendant solicitor and partner with BLM's catastrophic injury team. He acts for several major insurers and the MIB in the defence of high-value claims, which tend to involve severe brain injuries, spinal cord injuries, and amputations. He regularly liaises with his opponent solicitors and with case managers about rehabilitation and funding, while advising his insurer clients about these issues. We've also got Angela Kerr, consultant case manager, and she is one of the country's leading experts in the case management field, having been involved in the profession since 1992. She assisted in the development of Babicum, which I'm sure many of you are aware of, joining the steering group in 1996 and remained as an appointed treasurer until 2004, until being invited to take up the chair position in 2016. She founded AKA Case Management in 2002 and is now a consultant in that company. And she's also now the chair of the Institute of Registered Case Managers. And finally, we've got Laura Middleton-Giroud, who is a claimant solicitor from Irwin Mitchell in the Serious Injury Department, based in their London office. She heads up a team where the prime focus is on the client's rehabilitation and to utilise the legal claim to optimise it. She joined Irwin Mitchell in 2007 as a newly qualified solicitor before being promoted to partner in 2018. And she is accredited as a senior litigator with APIL and also holds a brain injury accreditation through APIL. So thanks very much to the three of you for joining us today. We do have quite a large audience. There's about 100 participants that we're hoping to join. So we are inviting questions throughout the session today. You should all have a Q&A function on the webinar. So if you do have any questions as you're going along, please type them in there. And then our plan is to put those to the panelists either as we go along, or we have allowed some time at the end for a Q&A session. Just because of the huge numbers that we've got, we probably won't be able to get through all the questions. So apologies up front if your question doesn't get answered, but we will try and get as many themes in there as possible. So thanks very much, guys. As you know, the topic today is how does case management fit in alongside the legal process? And the first question I'd like to put to you all is the duty of a case manager is first and foremost to the injured person. Their relationship with the client is therapeutic in nature, and they are not deemed part of the litigation team. But how do case managers ensure they stay independent and always act in the client's best interest whilst working alongside or within an ongoing litigation system?
It's a lovely question that I should answer really, Simon, I think, or kick it off. And I'm sure Andrew and Laura will jump in. And I think that's a lovely way to put it. But I suppose in a way, case managers are there for the client, as you say, and they've got to use all their skills and knowledge to set up a program that supports that individual to progress to independence and a better quality of life following their injury. But they are also part of a team. And as you build up a package for a client that's individual for that client, so is the team that's around the client independent as well. And there to share knowledge, share experience, but the case manager needs to be recording their evidence for the claim, but also acting within a code of conduct and code of ethics. And as you're probably aware, within Babicum, CMS UK and the membership bodies, there is a clear code of conduct and code of ethics that case managers can follow. And also those membership bodies and colleagues within the case management industry are there to support case managers and brainstorm, because we can't always get it right. And, you know, sometimes our best successes are because of the experiences that we've had in not doing so well in a way. But yeah, I'm starting to take over now, and I can see Andrew's put his hand up. So I don't know whether Andrew wants to come in and we can talk that through in general and in the round.
No, I mean, I don't disagree with anything you're saying there. You know, it seems to me that it is part of a team. It's part of a team that has to be able to put the claimant's interest first, as we were alluding to before. But it's something which is, for the case manager's role within the litigation, there's obviously certain connections between the case manager's role, the claimant solicitor's role, the therapist within the team. And it seems to me that part of the case manager's role in representing the claimant's interest is to very much put their interest first, to separate that from the litigation and from any influence that might come, whether that's from the claimant's team or the defendant's team. But also, so being prepared to challenge either one of those litigation teams, but also being willing to challenge your own team, your own therapy team, and being able to say to those therapists, well, I expect you to, create goals. I expect you to document what you do. I expect you to have clear aims that we're aiming to get to progress this situation for this individual. And so I think a key part of the case manager's role in maintaining that independence is to step back from all the litigation, to step back from the rehabilitation to some extent, and say, this is what I expect of these teams to get the best outcome for the claimant.
Yeah, and I suppose one thing I didn't mention, there are case managers in the NHS and probation service that do operate outside of the litigation side of things. And, as professionals, most of us come from different therapy backgrounds, nursing backgrounds, social work backgrounds that aren't naturally understanding of the litigation process. So we automatically think about the client first and should maintain that. I think it's when we get into conferences and discussions with the legal team, it starts to challenge our thinking, doesn't it, as case managers, which is a good thing, because in lots of ways it means that we're more grounded and evidence-based in why we're doing something the way that we're doing it. So it is a positive thing in lots of ways if you look at it in that respect.
I'd agree with you, Angela, that the need for the paper trail from both the case manager, the MDT, to evidence that rationale for a decision being made. And I do agree that with Andrew, which, for a claimant solicitor to agree with defendant solicitors, we're doing well with the first question. But that need to challenge that dialogue, reviewing the expert evidence and coming up with a rationale if the expert evidence is challenging a clinical decision, being able to explain that decision in a bit more detail, or saying why an expert recommendation might not work for that particular client in the particular context in which the client is operating. It might not work for the client and their family, for example. So I think it's all about dialogue. Yes, stepping back, reflecting on the goals, seeing what goals have been achieved, what goals need to be put on the back burner. But just communication, really clear communication line and paper trail. And I think that's a way for a case manager to keep the client's best interest at the forefront of everything that they do.
I mean, yeah, picking up on that, Laura, it's certainly something I encourage in claims I'm dealing with, is for there to be, your usual review meetings between claimant and defendant lawyers. But the problem with simply having those meetings where it's, maybe it's me and yourself discussing the rehabilitation, discussing where we think it might be doing well or where we think it might be failing, that can only achieve so much. And actually, I think a really important thing, something which the Serious Injury Guide encourages, is that you have those meetings, you bring the case manager along into those meetings, and it's an opportunity for either of us to ask questions of the case manager, to challenge the case manager as to whether we think it's, the paper trail is sufficient, whether we think that the goals are clear enough. And that can be really helpful because that's a way for the case manager to understand what our concerns are, and equally for them to satisfy those concerns, which might well help to progress the rehabilitation and make the funding flow more freely. I suppose I wonder, Angela, how often do you find that either you or your colleagues are getting involved in those sorts of meetings?
More and more now. I mean, back in the day, it wasn't so much the case because in lots of ways it was a little bit more adversarial. The defendants and claimants and insurers really didn't talk to each other. They're all very suspicious of each other. I think things have progressed a long way, and I think very much in the way that you've been talking, because it is the benefit of the individual. If everyone's aware of what's happening, why it's happening, then it tends to make the package, the funding, everything run a little bit smoother, because everyone's singing from the same hymn sheet. Whereas it doesn't always happen, of course. There are situations where that doesn't happen, and you get very conflicting information going to the client, and the client can get confused, the families can get confused about what's happening on the ground, why things are and are not happening, which can cause challenges for the case manager with their relationship with them. But I have to say, more often than not, it is a more collaborative approach, which I would say is best for all, really, and it feels best for all.
Yeah, and I would agree with that. And I think it's nice, you know, as a case manager as well myself, to see more collaboration. And I think it's really positive that the three of you have all agreed that actually communication and collaboration is a positive step forward that we maybe haven't seen as much of in the past than we are now, which is good to see, really. So thanks very much. I'm going to move on to the next question then. Regarding single or joint instructions to case managers, can I ask what are the panel's views on the pros and cons of each?
I suppose if I kick us off, I mean, the first point I'd make is, as defendants, there's always the question of when we're even going to be notified about the claim, and therefore how involved we're going to be at the outset in terms of identification of a case manager, preparation of an INA, and too often I think we're not notified until too late in the day, which isn't really in accordance with the rehab code. It's not really in accordance with the serious injury guide. But it can seem like a strategy amongst certain claimant firms, and Laura might well have a view on this, that in a case where someone's confident on liability, we might find that we're not being told about the claim until quite late on, after which time maybe the INA's already been commissioned, case manager's been chosen, and then we receive it with a request that we provide a large interim payment to fund it. And that's the sort of approach which can get an insurer's backup before we've even started the whole process, and doesn't really fit in with the sort of collaboration we were talking about a moment ago. So I suppose I put that out there just to start things off, because I wonder what Laura's experience is of that.
Thanks, Andrew. Well, obviously I can only speak about my own approach, my team's approach, and what we tend to do is quite different to what Andrew alluded to. So once we have been instructed, if the injuries are quite significant, but we are not quite yet sure about the sequence of events leading to the injury, and sometimes that's happens if the client is still in hospital, or because of the brain injury has no recall about what happened. But once we are able to identify insurers, we'll do the early notification letter saying, well, look, we know that the client has sustained these injuries. We're not quite sure about what happened, but surely there'll be a need for rehab. But if that early notification letter is not done, then in our letter of claims as precedent, we have a paragraph dealing with the need for an INA. So certainly that's not my experience, because the client's interest is to get rehab up and running, and you can only really do that via an interim payment. We have obviously a client liaison officer working for us where liability is denied. We can get help the client with referrals, etc. But in terms of the claim, then the first port of call will be through an immediate needs assessment and instruction of a case manager. So I think that's just to respond to you, Andrew, on that point. It's not my experience. In terms of joint versus single, it very much depends. And if we don't quite know how the client came to be so severely injured, sometimes joint instructions are a way to enable the client to access early rehabilitation. When we're still investigating liability, liaising with the police, liaising with the HSE, liaising with the insurer. Sometimes that can fall, break down where there's a disagreement about the choice of case manager. That happens. Sometimes they're not local enough. Sometimes they might not have the necessary experience, the ones that are put forward. So sometimes there's a breakdown there in terms of the choice of case manager. So I'm not sure there's a right or wrong way. Certainly the approach is, for us, do insurers want to participate in an INA? Sometimes we don't get a response from that to that letter until very late in the day. So that's the flip side, I suppose, to the point Andrew was making. And by that stage, yes, we have gone ahead with the INA because we want to get things moving. We want to be ready for when the insurer is ready to engage with us.
Shall I give you a little bit of perspective from a case manager's point of view? Because some people go, oh, joint instruction, what does that mean? Because sometimes, even though there's the code, rehab code and other guides, etc., it seems like it depends who's on each side as to what they're expecting of the case manager, and sometimes that's not clear. And the case manager can really feel right out in the dark who are we reporting to, how are we reporting to people. And I think from that, taking that point, what's really interesting and vital is as soon as there is a joint instruction, perhaps, yes, there might be some issue about, is that case manager appropriate? Are they too far away? Does the client like them, etc., etc.? It might be worth having a meeting right at the beginning and just agreeing those lines of communication, because the lines of communication can get very blurry and it can create some real challenges. So that's where it can fall down. But where it works really well is where those challenges of communication, where those lines of communications are very clear, especially if the defendants or insurers are invited into multidisciplinary team meetings at times, can progress things on really quickly because the claimant is often there as well, or the client, and you can see at first hand the challenges and the experience of that individual and how they're coping, how they're not coping, and you can see very clearly, or you can hear very clearly, what the team's perspective is and their priorities in relation to the rehab program, why they're doing things in that way, and it can just ease the flow of funds. And it sounds awful, doesn't it, when you think we're looking at insurers and defendants as fund monsters, but sometimes you are.
Oh, yeah.
Because that helps things flow, you know. It can make it very difficult when the money's not there. Because I have experiences where cases stop, start because the money's not there to fund it, and that's even worse. But anyway, I'm going off again.
but Angela, do you find that? I mean, I agree with the point you're making there about, you know, bringing everyone together, that early dialogue, agreeing the parameters. I think all of that's absolutely vital. But do you, in your experience, do you find that it tends to be more stop-start, whether it's a single instruction or a joint instruction? Which one, from a case manager's perspective, tends to flow and allow things to move on?
Now, I'm going to be really contentious here and say it depends who the solicitors are involved in the case.
Well, no, I agree with that, because I mean, I certainly find that it's about the relationships, and there'll be certain relationships between solicitors and between their firms, which mean that there's a certain level of trust, which allows people to make decisions, to take a view on the longer term and get things moving. And then there'll be other relationships where that relationship is poor, and that's the blockage to having that trust and being able to move things on.
Or it's the experience of the individual in handling what can be complex cases. And I'm thinking of brain injury and complex needs here, because the brain injury and complex needs are where you do need to get big packages in. So there's big sums of money that need to be put forward. And if you've got a legal team that aren't very experienced in handling those sorts of claims, it can be really challenging. And I have had experience of one firm that would literally, you do your case management plan that would be for, say, 3 or 6 months. You'd have your MDTs so that they knew where the funding was going, why it was happening. You might have to nip and tuck things, change things from experience of what's happening on the ground. And then the funding would just dry up after that 6 months, even though you would have hoped that they would have been ahead of the game, making sure someone like you, Andrew, was aware of what was happening. So that continuous money flow was there. But no, you used to have to stop, finish, not go in, get involved, or the therapist had to come away to wait for the funding and come back again. And in those situations, it's a really difficult one, because ethically, we've got a duty of care to these individuals, and the longer you're working with them, the more you want to assist where you can. So more often than not, you just stay in touch and you continue and do what you can to perhaps get other funding from other places until you can start up again. And also, clients can get into real challenges when everything just stops like that. What you're happening is things are stopping, the individual's got no support, so things go backwards, and then you're having to go forwards again. So evidentially for the claim, it's probably helpful in some respects for the client's needs, but from a personal point of view for the individual, it's not helpful because it's very hard for them, and professionally it's not great either. So yeah, I hope that answers your question.
Yeah, that's great. And I think Angela, hopefully you'd agree with this, but those issues in my experience can happen on either or both joint and single instructions, so yeah, it's not necessarily tied to one or the other.
Yeah, and I think again, so as we said before, I mean, what's happening currently, people are more respectful of that now, so things are changing more towards that positive collaborative working and forward planning. And I think the more we can do that, the more we can evidence the value of doing that, the more the client's going to benefit.
Yeah, I've just had a question come through from Joe Prackinson from Erwin Mitchell, and the question is: if liability has yet to be decided, does that influence your decision to agree to the joint instruction of a case manager under the Rehabilitation Code?
That one, because it's a home question. But I think the question is, essentially, I will have a discussion with the client. So essentially, it will be in the client's best interest to have that collaborative approach. It depends whether or not there are conditions attached to that make it quite difficult for the client. But I think my view is, if you're not sure as a claimant solicitor about how the accident occurred, you've still got to investigate, you've got to prove your case. And if there is an offer of funding in the interim, I can't think of any client who would decline it. Sometimes that offer can come with some strings attached, as I said. So do not issue court proceedings, otherwise we will stop funding. And that obviously puts the client in a bit of a difficult position if, for example, the funds that are on the table aren't quite sufficient. So it is very much fact sensitive, but as a matter of principle, my duties to the client is to maximize rehabilitation. If it's a choice between actually putting something in place now or having to wait a couple of months before we are clearer, then my advice will be, take the offer on the table, get joint instructions, get a good case manager who can get things moving, and maximize early rehab, for the client, definitely.
Andrew, do you want to? Yeah.
I suppose I looking at it from the other perspective, if liability is still an issue and still needs investigation, that's something that is going to be our #1 priority to try and work out where we stand on that. But in the meantime, that isn't a barrier to us looking at rehabilitation. But I would expect that it would be on the basis that it should be a joint instruction. And in the meantime, we'd be looking to progress the liability investigations as soon as we can in order to understand what our position is and whether that's something that we can continue with or not. But yeah, certainly at the outset, if we still need to investigate, but we're dealing with a significant injury, then a defendant insurer is likely to be very open to the idea of making funds available. That might not necessarily mean that it should always be a joint instruction. They might say, well, we're willing to make some funds available by way of a general interim payment, and that gives you a set sum of money whilst we're investigating liability to get things started. But it is going to be very case specific.
Thanks, Andrew. I'm going to move on, and there's been some themes around communication and collaboration coming in some of your answers already. So my next question to you all is, what does a good collaborative approach to rehabilitation and case management actually look like?
Well, shall I start us on this one? I personally find that collaboration is extremely important in what we do. It's the most important aspect of being able to move these cases on, whether it's in terms of the case management or in terms of the wider case. But I do feel that at times the use of the word collaboration amongst claimant and defendant lawyers has become a bit of a buzzword. And there are times when people say, you know, we want to be collaborative, but then what we find is further down the line, you know, we thought we'd agreed something and then that's not being followed through. And I'm sure Laura will say the same thing on the claimant side. It depends what side of the fence you're sitting on and how you view people on the other side of the fence. But that's why I think it's very important that the serious injury guide, which I referenced before, it provides you with that guideline, that framework for how these cases should ideally be run. And if both parties sign up to that and make it clear from the very beginning that they're willing to work in accordance with the serious injury guide, and that might mean that at times they're going to have to agree to disagree about things, but that doesn't need to stop you from still being able to agree what the end goal is, then that's great. But I think that my concern is that too often people talk about collaboration at the outset and then further down the road, that seems to disintegrate.
Can I just mention something? Because I feel sometimes, as we said right at the beginning, if we can get together and agree those lines of communication, it reduces the risk of the case manager being pulled into all of the different arguments that are going on between each lawyer, which that's your job and you've got to do that. But I think sometimes that can, you know, some case managers can be vulnerable to that, to be pulled in. And I think if there is a very clear line of communication, that means the case managers can get on and do what they need to do, which is look after the client's needs and ensure the needs are being met. And there's a very clear evidence-based reason for everything that's in place and a pathway through, and communicating when things are going well, when they're not going well, and what's happening, what needs to happen to ensure things continue to progress in the way that need to, because life is life and things come into the mix that can be unpredictable. And I think what I've observed in time and experienced myself is that sometimes when case managers are sharing information, the legal teams can get very heavily involved, and it can be quite challenging for the case manager to keep that independence and to continue to be strong. Go, no, this is what I can see is the right path for this client. This is the evidence I'm providing for you. You need to deal with that evidence in the way you need to for the legal claim, and let us continue to provide the service to the individual in the way that is working for them.
I mean, I think I agree. It goes back to the first point about evidencing clinical decisions. And I think that forms the starting point for good collaboration. If you've got that information as claimant solicitor, you have to share it with the defendants once the client, you know, has factually checked the documents once, and that can be circulated. I do agree with Andrew in terms of the serious injury guide not necessarily being applied in all cases where it really should be applied, and that's a shame. That's a real shame. My personal experience is where we have road mapping meetings, as we call them, every quarter or every 6 months or 2 months, depending on the activity level of that particular case. It does help in that the defendants have got a load of documents to satisfy themselves that things are progressing, what's happening, etc. So they are kept in the loop. And the flip side of that is that the hope that interim payments will flow so that there's no interruption in what the case manager and the MDT can put in place. I have been involved in many road mapping meetings where there are more disagreements than agreements, but that's fine. That's absolutely fine. And that's why there's litigation. We can't really agree on everything, but as long as there's an agreement that will happen, but it shouldn't impact significantly on the interim payment provision, then those meetings should carry on for the life of the claim. It doesn't always happen like that. And sometimes we do have to litigate to get interim payment applications before court where there's been a breakdown, or where maybe defendants or insurers do not agree with the path that the case manager and the MDT is going down. And that can cause some issues sometimes. But I think good collaboration is communication, sharing of documents, and agreeing to disagree.
Yeah, I mean, most defendant insurers ultimately want to understand what is the path to resolving this claim, and that has to be equally what the claimant must be interested in, because I've no doubt they want their claim resolved at the right level, so that they can move on with their lives. And that's why those early meetings are so important, not only to understand immediately what are we saying we're going to do, but we have to be looking to where is all this going? What can we map out what the next year, 2 years, maybe 3 years, however flexibly it needs to be, can we map out how we're going to get to that point of resolution? But with clarity as we go along as to when we're going to get disclosure, and then making sure we actually get it, not just having things landed on you just because you've got a meeting coming up, which is a huge source of frustration. But you mentioned before, Angela, about MDT meetings, and this is a good example to me of collaboration, because I know some claimant firms seem to take a view, no, you're not coming to this MDT meeting. We don't allow defendants to those meetings. Some seem to take a view, yeah, we don't have an issue with that. And then others, they're no doubt more case specific. You know, there'll be cases where the claimant themselves or their family might have a particular distrust, which means that they don't want the defendants to be there. But I have to say, from my point of view, I go to these MDT meetings on a fairly regular basis. I'm usually just sat in the back saying absolutely nothing. I'm there to listen and contribute if I'm asked to. But if I can attend those, and ideally if my insurer client can attend those as well, that's one of our few opportunities to get a real insight into who is the person at the centre of this claim. What are their needs? What are the problems that those providing rehab are experiencing, and how that's stopping the rehab progressing? So that to me is a really important part of collaboration, which is allowing us to see what those issues are. And I find that once they can put a face to that claim, many insurers are then going to be far more up to the idea of, oh, well, I understand what this claim is about. I understand what his difficulties are, and I understand how I might be able to help address those difficulties, so more funds will flow. So if there's a message I'd give to claimant solicitors, I think that those who are very objecting to that sort of attendance by a defendant, you know, I think that's something that defendants should be attending. They should be getting that insight, because it will help further down the line.
I mean,
Thanks, Angela, can I ask you to give a brief comment on that from a case management point of view, and then I'll pass to Laura, because I'm sure she'll have an opinion on that as well.
What was running through my mind there? I mean, I've been in MDTs where claimants and defendants and insurers have been there, and you can see the light bulbs go on for the defendants and the insurer. And I think where the challenge comes in this is life is grey, and sometimes you're looking for a black and white answer, and there really isn't. And so being able to see how things function in the grey gives you a better handle of the challenges that are going on and the unpredictability, because some clients live in a very unpredictable lifestyle that's really difficult to give a black and white answer to, or even project out more than, you know, like you were saying, 1, 2, 3 years, what does it look like? Well, you can easily do that, and all of a sudden they throw in a curveball and you're going off in a different direction. So I think that appreciation of the complexities sometimes is really helpful, and an MDT is a great place for that to happen, if at all possible.
Yeah, I suppose my immediate response is, well, I suppose it depends in terms of whether or not the claimant who will be attending the MDT feels that they can't quite express themselves as freely as would otherwise be the case if there are too many lawyers and insurers in the room. Sometimes there are quite sensitive issues that need to be discussed first before you can formalize a plan of action to deal with those issues. So I think it very much depends on the case. I mean, the last few years, I have to say I haven't been asked by a defendant solicitor to attend the MDT. Obviously, maybe after this webinar that will change. But I think from my point of view, as long as after the MDT, there are minutes, there are updated goals, there are reports from the MDT team, and those are circulated to the defendants early, I agree, then you have an opportunity of seeing, well, actually what was discussed, are there going to be any changes to the way the MDT is operating, to the goals, changes to the goals that have been set by the client and for the client. So I think that would be just the caution that I have around attending MDTs. Not so much in terms of road mapping meetings where the case manager or the deputy might be asked to attend as well. That's not something necessarily we object to. We're just on standby if it turns more towards cross-examination than a simple discussion. But I think for road mapping meetings, it's because it's lawyers, case managers, deputies, insurers, etc. Sometimes we can speak more freely than we could if a client was there because of the sensitivity of some of the issues.
Thanks very much. I'm gonna move on because I'm sure we could go around the tables again, but I'm gonna change tack a little bit if that's okay. So my next question is: a case manager is not an expert witness, but can be called as a witness of fact. What does this mean in reality? Is it achievable? And what support, if any, should be given to case managers when being called as a witness?
Well, I suppose I'll start with that one. I would say it's very much down to the claimant solicitors to ensure that the case manager doesn't freak out when a request lands on their desk or in their inbox about giving a witness statement. We were talking about the paper trail earlier, evidence-based goals, updated case management reports, clinical reports, and all of that serves to back up the clinical basis for any decision. Now, in terms of the legal claim, the case manager is the conduit between the legal claim and the client, and there will invariably be issues between the parties around the level of care, case management, vocational issues, whether or not the client's got capacity or how they're faring in relation to any budgeting tasks that have been set by the occupational therapist, for example. And so a statement is an opportunity for the case manager to simply set out, well, look, this is why I've done this. If it is sufficiently evidenced in a report or a record, you can refer to that. But it's simply for us, I see my role as just flagging up, well, these are the legal issues in the case, and you've had to deal with them just because you are the case manager and you're putting various goals in place for the client and going through that with them. It's got to be their voice. That's quite clear. Having the paper trail does help put something together, but ultimately it has to be in the case manager's own words. And I would say that it's really quite an important exercise. It's not simply a case of appending the report because the case manager could be called at trial. So it's important to have their rationale, their words in paper on that witness statement. And the reason why it's important is since that case of Lachlan, where the court forensically examined what the case manager had done or not done. And that can have a huge impact about recoverability of past case management costs. And that can have obviously an impact in turn in terms of the client's compensation award. So it is quite an important exercise, but it is very much down again to communication between instructing solicitors and the case manager.
Do you want me to say anything? I mean, again, it's an interesting one, and I think we go in as case managers to provide for the client. We know the litigation's going on. We hope we don't have to go to court, but there is that there. And again, I go back to when I first started, we were in and out of court more frequently than ever now. And preparing for it is very much are related to the lawyer that you're involved with or working with, and your witness statement, because your witness statement is really your pro forma to the delivery of what you'll provide, your evidence. But there are other training courses as well, because in some cases the arena of the court is like a theatre. It's, you're either very good in that arena and you can remember everything that you need to say using your witness statement, or you're not. So doing some training courses to desensitize, or even sitting in a courtroom just to desensitize, can be really helpful as part of preparing for having to be in the courtroom, because it is quite an experience. I can say that, but that's your theatre. You too. You live and breathe that most of your working life. But for a case manager, it can be quite onerous. So yeah, definitely doing some training courses and desensitization can help too.
I was going to say, is there much in the way of training on issues like contents of your witness statement from the likes of CMS UK and Babacom? Is that something that case managers get a lot of training on?
Well, there are training courses out in the case management industry. Yes, the membership bodies will provide certain key areas to focus on, but there's other organisations provide that as well. And certainly lawyers offer that service too to case managers. So I think it's asking the question and going, yeah, I really need to be confident in this arena, because it's about confidence. Because if you feel confident, then you do deliver everything, because you will know, you do know your case. You've been working with it for probably a long time. You've got a good rationale as to why you're putting all of the rehabilitation and the services into that client in that way. In an arena like the courtroom, it's very difficult to remember why you are doing it sometimes. And if you've got a very clever barrister, he can really challenge you on those areas and really unravel it sometimes. So yeah, I think it's all about desensitization, getting that confidence in that arena just in case. But also, in some respects, it bolsters your clinical expertise as well, because if you can justify why you're doing that in a courtroom, you can justify it to anyone. So you're very strong in why you're doing it. So it's a positive thing. It's just a challenge to your thinking, which is always good.
I mean, obviously from a defendant perspective, we only see the witness statement when it's served later on in the claim. And at that point, I mean, we said, they're a witness of fact. I think that's the important point. They're there to be a witness of fact, not opinion. So commenting on the input they've provided and the response to that input, absolutely fine. But where the sticky area comes in is when case managers might then start expressing a view on what that means for the need for that input to continue, whether it's at that level, at an increased level, a lower level. And that, of course, is where you've got your crossover with your experts. But that seems to me that's for the claimant solicitor to manage. That's something they should be steering the case manager on, as Laura said before.
Yeah, and I could say with hand on heart, I've been in the witness box a few times, and I was in a situation where the defendant barrister said exactly that, and the judge turned to me and he said, well, actually, I see Angela Kerr as an expert in this case, and I am going to direct questions to her in that respect. So you never do know, do you, how you're going to be questioned? And if you're in that arena, you're under oath. But I think going back down to sort of training, at least then you are prepared for not stepping into that arena inadvertently.
I think there can be some grey areas, as Andrew mentioned. I think sometimes it's not unusual, and it's certainly encouraged for a case manager and the MDT to think ahead over the next 3, 6, 12 months' time. So sometimes that comes across in a witness statement simply because that reflects the thinking of the MDT at the time, saying, well, we've thought about support worker input and we've had a discussion, and that's the clinical recommendation for that support worker input over the next 3, 6 months. I don't necessarily see that as, I mean, it is clinical opinion, but it's also fact, because that's the discussions that they've been having as a team. So there are some grey areas. I think I agree with Andrew. The CPR is quite clear, so they can't really say, well, actually, when they are 80 years of age, then I predict that they will need 100 hours of support worker input and case management input, etc. to that level. That's where we would get a care expert to comment on to do that long-term prediction. But certainly short-term, that's what any case manager would be expected to do, in my eyes anyway.
Great. Thanks, guys. That's great. I'm going to take a couple of questions from the audience now, and we have had some questions coming through, but if there's any more questions from the audience, please continue to send them through on the Q&A function. But a question's come in from Claire Lighton. I'm currently seeing an increase on my cases where liability is admitted after a joint instruction under the rehab code is in place, and the claimant solicitors decide to change to a unilateral instruction, even though a joint instruction is working well and the claimant's needs are being met, etc. Why do you think this is happening?
I mean, it's very difficult to answer that question without knowing the specifics of it. But it may be that sometimes there are issues with maybe the defendants thinking that it is working well, but the funding not necessarily being as required for the case manager to plan over the next 3-6 months or so. So sometimes that happens. Sometimes it can be because you have maybe compromised a little bit on the case manager because you've wanted to get things going on the joint instruction front, on the rehab front. But actually, maybe another case management might be better suited to that particular client or set of circumstances. There might have been developments in the meantime, which may influence a claimant's decision to switch case manager. So there are a number of factors. Sometimes it is about having an opportunity maybe to request larger interim payments to have a bit more control over the planning going forward. But I really, it very much depends. It is, fact specific. I'm sure Andrew will have a very different opinion to me about that.
Well, I probably have a more cynical opinion, which is that I think your final comment there about it being a question of having more control is probably part of it. In circumstances where you're going to recover the full sum, being willing to speculate those interim payments as you see fit. And I think it is, in my experience, it is probably more about control. It doesn't have to be as much of an issue if you're still working collaboratively, if you're still having that dialogue. And I can think of cases where it's happened the other way around, where it's been a joint instruction. Me and my client have lost faith in the case manager, or we've lost faith in the claimant's solicitor challenging the case manager. And so we've actually been the ones who've said, we're not willing to continue like this anymore. We will provide you with interim payments, and then we make those interim payments on the basis that we have a framework in place whereby we still hope to work collaboratively, we still hope to exchange views on how things should move forwards, and what the framework is to settlement. We still get the disclosure on a regular basis. But if you're saying you want to stick with that case manager and we're not happy with them, then you take the risk, and we may well be raising the same Laughlin and Singh arguments that you mentioned before. That we're going to be raising those. So I think it can go either way in many ways, but it is case specific, and it depends on how your case has progressed to that point. And it's hard to say in any particular case, but I certainly suspect it's more about control than about anything else.
I think the only point I make is yes, even in those cases, and it's happened on a few of my cases over the years where there is that switch, there's still that disclosure, there's still the willingness to have road mapping meetings and so forth. So that doesn't tend to be affected by a change of the nature of instruction of the case manager, certainly in my experience.
Great, thanks guys. We've got another question that's come in from Anna Brew. And it's what thought is given to the winding up of the case management provision. On the defendant side, it often feels that we are tied into ongoing rehab that may not necessarily still be required. And as the defendant, we would like to see more evidence of the thought process as to the exit strategy for case management. Any thoughts on that?
Shall I? Oh, sorry, Angela, you go ahead.
No, it's an interesting point, isn't it? I mean, I would say that probably from a case management perspective, you're wanting your client to be as independent as possible. Some individuals will always need case management at some level and increase case management as life goes on and throws challenges at them. Some people will take a break, and some people, you will get to that point where they are independent and they are able to function with an open door to you. And ultimately that is doing yourself out of a job, but that is really what we're there for, is that independence, to ensure the client is living their life in their own way, under their own steam, with your minimum contact. So I don't know whether you can say you're winding up all cases, because again, it's back to case specificness, isn't it? It's I mean, I've worked with clients for 18, 19 years and still do, because they need it. They need that service, not about me being there unnecessarily. So it is always back to client need and how you work it on that basis, and the information and evidence that you provide for that. If there is a closure, then you will be working towards that closure when the time's right.
I was having this same discussion with my insurer client yesterday on a case in which the case manager has submitted a report, which we, I thought was a very balanced report. And it surprised me because I wasn't expecting it to be a balanced report based on previous experiences. But it came across as balanced. And one of the things we both agreed that we saw as being a positive in it was that it wasn't saying that case management's going to finish anytime soon. It wasn't suggesting that we're anywhere near the end of rehabilitation. This person's only just had some very significant surgery, and the rehab path is going to still be a long one. But what it was doing was saying, as we said before, about short, medium, long term, it was trying to give an end point to saying, well, with certain therapies, with certain levels of support, we introduce them, we then start to reduce them, we try to avoid encouraging dependency, and therefore, from an insurer's perspective, they can at least see that there's an effort here to get to that end point. And what can sometimes happen, again, on a different case of mine a few weeks ago, I had a meeting with a case manager. And in that one, there's a lot about, well, we need to do this, we need to add in this, we need to add in that. But that was all saying, let's do all of these things. But there's no discussion at all about how over time that's going to change, how it's going to morph into what could be a long-term package. So it might not, when we said about the end game of case management, it might not mean everything ending. It might just mean getting to like a maintenance phase, realizing that you've done everything you can possibly do with the rehab. You've achieved what you're going to achieve, and identifying when that point is. So I think that's what insurers are sometimes looking for.
I suppose from my perspective, it is simply going back to the core of this webinar is about the discussion between the MDT and the case manager about goals, about what you're trying to achieve with the client, for the client, and trying to plan. And I think if that's in place, then, for some cases, you might be able to reach a maintenance regime, as it were. For others, it will be stop and start as the client crashes and burns. And for others, it will be a sustained level of input simply because of the severity of the injuries. But there should always be that thinking of, well, what do the client need? Is it helpful? Will it maintain their gains? Or can I step back and other therapists maybe take the slot available in the client's diary to take things forward? So I think it's again down to that clinical reasoning and being able to step back from crisis management in a sense, and having this thinking of, well, am I still needed? Yeah, if so, to what extent?
Can I add a bit of a sub question in terms of, I guess, when a case settles, and I guess there's a whole nother complexity there, but in our experience, often case management input, the intensity changes once a case settles, and that's often linked to financial expenditure, and the clients or the client's ongoing financial management team sort of having a bit of a cautious approach of things, and just, I guess, getting the panel's thoughts on any pros and cons of that, and whether that's always necessarily the right approach to take, or is that just the nature of the beast? When a case settles, things are likely to drop off a little bit in terms of case management intensity. And maybe Angela, I'll start with you in terms of maybe your experience of that, because I'm sure you've had many cases that have settled over the years.
It's a challenge, this one, isn't it? Because I think your point about the financial constraints is the key, because you can get a claim settled and then maybe it was the liability was uneven, and you've got a claim settled on the basis of some discount because of the liability, and then therefore there's some hard decisions, and I'll defer to Laura on that to perhaps discuss that from deputy or financial deputy's perspective, or even who's managing the money for the client, because just have to maintain their lifestyle and their lives going forward until the last breath, as they say. So I think it's knowing that at the outset, isn't it? If this claim is going on, then it's perhaps looking at where the other funding can be found. And sometimes that is through NHS provision or other routes, maybe, being creative about it, working with the person managing the finances. But my experience of it is that sometimes claim can settle, and something in that client's life can mean that you need an awful lot more input than actually has been accommodated because something else comes in, or the family decide no, they're not going to be involved in helping this individual anymore, and there's a more, so things can change from a critical perspective where you haven't accommodated for the crisis that occurs unexpectedly. Or you get a situation where the client has got that litigation fatigue and they want everyone out of their life for a period of time, but then to come back in. So there's lots of different permutations there, and it's a good point to debate, but I'll probably suggest Laura's probably got some insight into this as well, as Andrew as well, perhaps.
Well, I'd say it depends. So I have some clients I'm still in touch with over the years, and who have maintained, they've still got care needs, they've still got therapeutic needs going forward, so that nothing has changed for them. And others, it's true, have had to cut their cloth accordingly. So as Angela referred to, sometimes there is contributory negligence. So sometimes claimants are partially to blame, or can be found to be by court, by agreement. And they may make the decision that actually they want to spend as much money as possible early on to maximize rehabilitation outcomes. And that's especially so if they're a bit young, they want to maximize educational achievements, maybe vocational retraining, or independent living transition. So I think that may be where you have a lot of input on the understanding that at some point the client will have to cut their cloth going forward. Even when there's no contributory negligence, sometimes there's disagreements between experts about what would benefit the client going forward in terms of care, case management, etc. And that creates litigation risk. So even if you recover on a 100% liability basis, there might still be some compromise in terms of what the client ultimately receives by way of compensation. There are also issues that do crop up that will make a client more cautious. So our colleagues in IM Asset Management will say that the client's profile in terms of investment is low risk because of that concern of the money running out when they need it most in old age, or where life throws something at them that is completely unexpected and they have to have the funds to deal with that. So there are issues around life expectancy. Sometimes, certainly my experience is that insurers aren't necessarily keen on period of payments for care and case management. So you have a lump sum that the claimant or the deputy has got to manage long term. And if the client outlives their expected life expectancy, the investment risk is on them, is on their shoulders. the deputy's shoulders to make sure they've got enough money until the last breath. There are still issues around accommodation claims, and so there's invariably some shortfall. So if the client needs adapted accommodation, they will have to make up some element of that shortfall from other heads of loss. And you're right, Angela, sometimes a deputy will be involved and they've got reporting obligations to the Court of Protection, the Office of Public Guardianship, which means that they've got to make sure that there's enough money in the pot for contingencies. And sometimes that does mean taking a more cautious approach on some of the expenditure going forward. So there's a number of factors that are at play here. And it might not necessarily, it might be the wish of the claimant to just continue on, as before, but because of the financial constraints or concerns about old age, planning for that, there might need to be some tweaks made to the care package.
Thanks. Andrew, do you want to, I'm going to cap you to maybe about a 30-second response if I can, but do you want to have a response to that?
Yeah, I was just going to say, I think it's a bit of a murky issue. While I hear what Laura says, the reality is that claimants these days are recovering more than they ever have before. Changes like the discount rate, accommodation, Swift and Carpenter, they're recovering larger and larger sums. Case management is one of those things which, again, is now being recovered at higher and higher levels, both in terms of annual sums and where there's even steps in provision of case management in terms of expert reports and what they're suggesting for the future. So the reality is that it seems that what's being described is they're choosing to jettison case management over potentially, other things that could be jettisoned. So I'm not sure I entirely buy that, but I think either way, it's something that I'd be interested to see more research done into and more statistics as to how often is it kept in place, how often is it reduced, and that seems to me something that would be interesting for some of the case management authorities to generate that sort of information.
Thanks, Andrew.
certainly from my experience though, Andrew, it tends to be more that you're involved and not involved. It's the degree to which you're involved. It could be higher, could be lower. But yeah, good point though.
Yeah. Thanks, guys. And maybe that's a nice topic for a future webinar debate, maybe around the post-settlement aspects of case management. That can probably be a whole nother hour, I would have thought. But thanks very much. I'm just conscious we've just come up to our 1 hour limit, which we'll try and stick to. So I just wanted to thank everyone, Angela, Andrew and Laura. Thank you very much for joining us. There's been some really good themes around communication and collaboration and joint working, which I think is really positive to see. And it's nice to see a defendant and a claimant solicitor agreeing so much. I think that's proof that collaboration does work and can work. So thanks very much, Andrew and Laura, for that. And thank you, everybody, for joining us. This is the first of several webinars and presentations that AIMSCO Associates are going to be running over the next 12 months or so. So please do keep an eye on our social media channels for upcoming topics. And we hope to see you all again shortly. Thanks very much for joining us.